In this episode, the elephants meet the New South Wales Bar Association President Dominic Toomey SC. They discuss his successful trip to the High Court in the seminal police powers case of New South Wales versus Robinson, why theatrics in the courtroom don't often persuade, and how a strong bar association is critical to upholding the rule of law.
Welcome to Elephant in the Courtroom, a show where we look behind the routine appearance of the law and speak to the key people in it. My name is Nick Hogan and this is Awais Ahmad.
Hello. We
are two barristers practicing at the New South Wales Bar in Sydney. And today we have a fantastic guest on the show once again. He is Dominic Toomey of Senior Counsel and he is the current president of the New South Wales Bar Association. Awais, very much looking forward to meeting Dominic today. Have you got some questions for him, things that you are interested in?
Yes, I think any opportunity to speak to the president of the Bar Association is one that we should relish and take seriously. The fact that he is not only a leading senior counsel and a very respected one, we can learn a lot from him in terms of court preparation, cross-examination, but we can also learn about how he manages to juggle being the president of an association that is very interested in being an advocate, so to speak, on certain rights. And it's also great just to have him endorse and speak to us about some of the issues that are important to him.
Like you, he's been at the High Court, hasn't he, Vasi, as well?
I understand
so you
that.
guys can talk shop about that, can't you? And in all your great sort of humility and modesty about the fact that you've been there and dare I say, and we have mentioned on the show previously, had some success there.
Yes.
Dominic himself did have success when he was lead counsel in the High Court. So
well, Mr. Toomey and I have a lot in common then, don't we?
I'm not sure if I'd put you guys in the same cupboard, but
not many would.
Yeah, no. But anyway, so courts, the bar. We're talking hierarchy, you know, obviously it's a hierarchical system and world we live in, full of rules and protocols and deference, traditions. Those things, at least to my mind and in my experience, create opportunities or situations that are just innately comic, either because they're embarrassing, awkward, in the moment, possibly even tragic to you as the barrister being involved. And only afterwards sometimes you can laugh at those.
Yes.
Have you had any of those? Because there's one of them I'm going to cover with our guest today,
right. But
we can get to that of us. And I know I don't want to see you squirming in your chair at all over that one, but because obviously there's nothing to squirm about. But do you have any of those? Have you had any of those awkward moments?
Isn't it just an occupational hazard of being a barrister? I mean, by definition, we are there as the face of a particular issue, being judged on every manner of things, including how we stand, how we speak, how we address the bench, and often the substance of our points. And so often you get caught up in trying to perfect that you invariably stuff up along the way and make a fool of yourself.
Things can just start to go wrong before your very eyes,
yes.
Can't they? I mean, for example, you might be cross-examining a witness the night before or the days before. You've prepared this excellent cross-examination.
You've done it in the mirror a million times.
You've done it in the mirror. You've got all these great bullets to fire as such, or these things to put, and you think it's going to go wonderfully. And if they say this, well, then I'll ask that, and all that sort of stuff. And then you start asking questions, and everything just seems to be going south. Have you had any experiences of late where those sort of things have occurred, where you're in court and you're just thinking, "Oh God, I want to shrink and
Nick,
disappear into the ground"?
Disappear into the ground.
Was the question back? How long have you got?
Or how long have you got? I mean,
Vasi,
it's an occupational hazard.
They have happened to everyone of us.
Sure, but that's the point. Yeah. Like part of being a barrister is one of the challenges to it is being the face of your client's particular issue, a legal point, a procedural issue. If you've been delinquent with the court's timetable, you are the face of all hostility, generosity, and I guess, applauds even at times.
But the great humility that has to come with that, inevitably. I mean, I can't say that all members of the bar are humble in my experience, but many of us are and have to be, because you are just this unit that has to bear the good and the bad.
Or you can be, self-deprecating and not take yourself too seriously, which is what we at least try to do sometimes. Look, there are so many embarrassing moments. I mean, I could rattle them off.
You were telling me about something involving some legislation the other day before we started.
There was a situation where I came up with the most intricate, extravagant, eccentric but undoubtedly correct submission with respect
one
to
of your exotic arguments, that, likes of which we would. Well, Malcolm Turnbull said that the exotic argument was the one that won him the High Court case against the publisher in the Spy
You've got to be brave in this game, Nick. You've got to be brave, and so it was undoubtedly correct, except when I realised on the morning of the argument, when I was printing out the legislation to support my argument, that I was referring to WA legislation and not, in fact, the relevant New South Wales legislation.
Because we're in New South Wales.
Yes.
Did you wake up just realising, actually, I'm in a different state?
I was looking at like an ordinance and a regulation that just kind of mirrored the state-based one, and then I came up with an argument based on that. But then when I was printing the legislation, I saw WA on the top, and I thought,
So that was an embarrassing moment, a private embarrassing moment.
No, but I had to then turn up to court having already filed the submissions.
You'd written the submissions and filed them.
So then I had to sort of just, as any good barrister would do, nothing to see here, next submission, please.
And no, did you say these are the cognate provisions? You know that term where the cognate provisions, the ones that are similar or similar enough that they be anything about them or submission I make about them would be applicable to legislation here.
If you would like to hear a hypothetical scenario of how this might apply in WA, I'm happy to tell you about it, but it has no moment here. Look, there are other moments when I think I paused to ensure that the judge said to me, Mr. Ahmad, that's not your best point. To which I paused and stopped him and wanted to clarify that he didn't say, that's not my best point. I said, Your Honour, did you say that's my best point or not my best point? And he said, not your best point.
Yeah.
And I was very grateful for that clarification.
I had a situation the other day where sometimes in court you have a very quite friendly exchange with the bench. And you
become familiar,
and you become because you're so pleased that it's going well and that everything seems to be happening easily and satisfactorily and even indeed possibly in your favour. And so you get to a point where you act as though in your mind tricks you into thinking you're speaking to a friend. And so you might just be a little bit too familiar or a little too friendly with them. And the judge, we were talking about, it wasn't anything complicated. We were talking about dates when things needed to happen. There'd been an application and then there was some orders that needed to be made and more things that needed to be done afterwards. And so these dates were being discussed. And this was a date that didn't involve me. It was something the other side had to do. And I, just because we're there, are all talking, and I said, well, Your Honour, I have a trial that week, and because when you're a barrister, when you've got a trial, that's when you're really doing your job.
I can't be here. I've got something important.
Your Honour, I'm important, And of course, he must sitting there thinking, so what? And he obviously articulated that. He said, well, good for you, Mr. Hogan, and good luck with that, or something words to that effect. And I just shrugged a bit and I thought, that's right. I mean, you still got to remember where you are. And
has Chris Taylor regaled that story, although it's a long one, about the time that I embarrassed him in the opening?
No, but if you could keep it to 5 minutes or 3 minutes, how about
in short? I was in the beginnings of my time as a jury advocate, and I wanted to understand the sort of the processes of how to have a jury brought on to and been picked and empanelled is the word.
Chris is a deputy senior Crown prosecutor now. He's very experienced, was even then.
Wonderful mentor and great gentleman, but he had the humility to invite me to watch him empanel a jury so that I could see it for my trial that was coming up. Now, he told me to be there on time, and I suspect I didn't realise the significance of that point because I was just coming in to watch what probably I'd figured out reasonably well by then, but I had a spare day. So I came in a little bit late and I burst through the doors and her
Dressed in your best suit.
Yeah.
I think Chris told me that you might have even had a pocket kerchief.
I think I was going through a phase.
Yeah,
I was in my
You were a matching pocket kerchief tie phase early on.
Yeah,
you
well,
are.
you know, I was a big guy. I was a big barrister back
Big
in
man
those days.
on Phillip
I
Street,
was,
and you
was
were
in the local court most weeks.
and you were going to watch a jury empanelment.
So
you weren't really.
I needed to be,
looking your best.
Looking my best. So, anyway, and then the judge said, "You can't come in," and Mr. Taylor then obviously said to Her Honour that sheepishly he's with me. At which point the judge then said, "Look, go on then, sit down," because it's a very serious process in panelling a jury, and it's a very overcrowded courtroom, and me being in there was just one person too many, I think. But then I sat down where I was directed to by Mr. Taylor, but then the judge said, "You can't sit there." And so I was sitting on my wheelie chair, much like this, just wheeling my way,
Moving just crabbing across the
into
courtroom.
this empty space in the middle of the courtroom.
And was it pin drop material? Was
No,
it?
it was
Everyone
terrible.
was
And
waiting for you to.
I just wanted the ground to swallow me up because I was like, "What have I done? Did I need to be here?" Okay, and then I'm sitting there quietly, and then I keep getting shoved along by Her Honour because there needed to be a pathway for the jury to go up into the box. Anyway, then when the judge then asked the broader pool of prospective jury members if there was any reason why they couldn't sit on this trial,
I love this bit.
one particular gentleman stood up and said, and I heard the sounds because I had my head to the ground out of shame.
Yeah.
He's known to me.
How embarrassing!
And I was looking down. I was like, it can't be me. Like this can't.
This day can't get any worse.
This can't get any worse. And I turned around, and it was a bloke that I'd caught up with many years earlier at a party, and I barely knew him, but it was just so he was then immediately disqualified.
He couldn't be.
He couldn't be in the jury, and it just looked all a bit too rehearsed, perhaps. But anyway,
But you found your position and you got on with life, and then you've had your illustrious jury career,
Yes,
your jury trial career, which was obviously spoken about a number of times since. Vasi, we're going to speak with Dominic about skill set today, courtcraft a little bit, cross-examination. You do a fair bit of that in your family law matters.
Well,
Do
I think.
you find it difficult?
What is it about? Yes, I do. Last night I was addressing the new reader intake in their advocacy course. They have a day-to-day session through various skills, and last night was cross-examination.
Were any good cross-examiners in there? Any
I
naturals?
thought some of them were brilliant. In fact,
Really?
I think some of them it was some of the best I've seen. And because often when you are against an opponent, you sort of
You admire things that they do, and you think, gosh,
that's a good way of doing
there's
it.
an effortlessness about it that I've noticed, and the people who are good,
Yeah.
they just it's not aggressive, it's not boisterous,
Yes, and it's
quite gentle, actually.
conversational. Because what are you really doing in cross-examination? In my view, this is what I was trying to impart on them yesterday, is that you're eliciting concessions, you're qualifying facts, you're contradicting facts, and you're challenging facts, all within the confines of your case theory. But to elicit concessions, to qualify their state of an aversion given, but then to ultimately contradict and challenge, you need to be fully prepared and know your brief inside out.
Yeah,
and
yeah.
I think that's what makes it so intimidating, because often people think a lot rides on it.
Yeah, do you need to get that? That might be Dominic.
Let me check.
Will you check? Just go. All right.
Hello, Awais, Ahmad speaking. Dominic's here. All right, wonderful. We'll be out soon.
Well, that's probably enough from us, Vasi. Do you want to come back onto set and we'll get started?
Sounds great.
We'll be right back with our guest, Dominic Toomey SC. So today we have Dominic Toomey of Senior Counsel on the show, the current president of the New South Wales Bar Association. He was called to the bar in 1999. He was made Senior Counsel in 2015. Then in 2022 to 23, he was the Vice President of the Australian Bar Association. And now in 2025, he is the current President of the New South Wales Bar Association. Welcome to the show, Dominic.
Thank you, Nick.
And thank you for paying us the compliment of coming on.
Not at all.
I just wanted to sort of clear the air with something. I affectionately refer to this incident as Bridgegate. In circa 2024, I understand that one of us, Ahmad, was travelling across the Anzac Bridge. And one might call this a bad career move, that when the would-be president of the Bar Association is driving in a nearby lane and who's someone who's also an expert in tort law, what one would do well, particularly when one's driving a car with what one described as highly personalised number plates on it, to avoid having a near miss of running that yourself, in this case, off the road. And I just wanted to provide you with some comfort before we get going that Awais' interviewing skills are somewhat better than his driving.
Oh, I hope so.
Yeah. So I just thought we'd get that out there.
We were talking earlier about instances that you want to be swallowed up whole, and thanks for bringing this one up. We were talking about some embarrassing moments in court, and I got to say, veering into a whole lane to my left whilst distracted by a cricket podcast.
Distracted.
Distracted. Was not my best driving moment.
Dominic, now we've got that out of the way. You, of course, your father was an eminent QC when he was at the bar.
He was.
Had highly respected, and dare I say, known. And you may disagree with me on this. Known for his fairly robust style of advocacy or cross-examination. He was a very good cross-examiner, but quite, I think a lot of people use the term fierce. Did you ever experience him in court when you were young and observe his skill set?
Well, I experienced his cross-examinations well before I saw him in court. Yeah, that they were generally conducted across the kitchen table when I came home well after the appointed time.
I was going to ask you that.
I
were there
found
any
them
instances? I was going to say, were there any experiences where you perhaps mucked up or been missing in action, so to speak, and then you incurred the skill set, full on face to faces to try to get him getting to the bottom of what you've been doing?
Many. Yes.
And did you then?
So, sometimes I managed to evade it, but other times he shut the gates.
Shut the gate, exactly. Yeah, that's right.
Mind you, I was frequently at a disadvantage because, generally I'd been a naughty boy and, in my late-ish teens, I'd probably come home a little under the weather.
Right, so that was your first encounter with shutting the gates, which is now part of the, I suppose, any decent barrister's armoury, practising barrister.
Yeah, I heard Michael McHugh Senior describe it the other day in an interview that he did with Michael Kirby, which will be published, but I heard McHugh describe it as the stepladder approach. But what he was describing was what we've come to understand as the shutting the gates method of cross-examination.
Just for because it might surprise you to know there are some non-lawyers who we hope, and I in fact know, listen to this podcast, if only.
Or very famous now, Nick.
If only they be family members. Yeah. Just describe in shorthand, if you can, the shutting the gates method. It's critical to cross-examination. It's one of the things you really... could you give me an outline or give the audience an outline?
Yeah, well, generally speaking, what you're seeking to achieve through cross-examination is to obtain evidence that is helpful to your client, whether that be through adducing that evidence from the witness or through their evidence by having them make concessions that former assertions they've made are not correct. And the shutting the gates method involves starting with general propositions and finishing with your final proposition. But the idea of shutting the gates is that you get answers that you want to general questions and the questions become more particular. And the very skilled cross-examiner does it in a way where the person who's being cross-examined doesn't realise that their escape routes, as it were, are being cut off with each answer they give.
They're being painted into a corner.
Effectively, they're being corralled into the centre, and as the term suggests, the figurative gates are being shut behind them, so that when you come to put your final proposition to them, they recognise. Sometimes they don't recognise, and you have to remind them that they've already made an earlier concession, but they recognise if the method's been properly executed, that there in fact is no escape. And the proposition that you're finally putting to them, they have to agree with.
So how do you go about preparing for that in your work? I consider that sometimes to be the most challenging part of the case preparation.
Well, I think one of the most important things about cross-examination is always to focus on what your final objective is. So you start, at least I do, in my preparation, I start with the matters where I want or indeed need concessions from witnesses whose evidence is inimical to my client's case. And from there, you have to look at the surrounding circumstances, the other evidence you anticipate will be given. A lot of it I say, of course. You have to have.
There's a human psychology in shutting the gates, isn't it? Because what you're ultimately relying on is someone is not going in the ultimate proposition that you're putting to be embarrassed by the fact that they've said all these things that they can't contradict themselves. So they have to, you hope, concede because they'll either be seen ridiculous and they're in a court and this is a very serious environment. If they disagree with you, they'll seem ridiculous. So there's a great sort of psychology in shutting the gates, but I think in cross-examination generally, isn't there? You need to appreciate what humans are likely to do in certain situations and how humans generally think about things. And the people who are good at it, I think, have a great sense of that. There's an EQ in it, I think.
No doubt about it. And the poor cross-examiner goes in too soon with the final proposition. And they've left too many escape routes, or they have left escape routes, and good witnesses will take it. Look, sometimes a witness is just honest, and if the final proposition is put to them too soon, they'll accept it anyway. But the risk is that they won't.
Yeah.
Do you write out your questions, or how do you go about planning it?
No, I don't. I never have. I go about planning it by reading all the material carefully and sometimes having a mud map plan as to how you go about it. I think it's very dangerous to be too prescriptive in examination in chief or cross-examination, particularly in cross-examination. In examination in chief, often you want to get in and get out fairly quickly. Adduce the evidence you need and sit down.
That's what's scary for people like cross-examination, though, because you really, to do it well, you shouldn't over-plan it, because you need to find your way in based on often what the witnesses gives to you while you're doing it.
Yeah, that's absolutely right. And we all give this warning to our clients that when they are under cross-examination, they should simply answer the question that's asked of them and answer it truthfully, of course. The people who then want to embark on a narrative are simply providing more material for the cross-examiner. And I think that I have won many cases from the evidence that's been given by witnesses called by my opponents.
Yeah.
Many. And really, when you're acting for a plaintiff, your objective is to force the defendant to go into evidence, because in many cases you know that there will be concessions that they will make which will be helpful to you. And indeed, in some cases, it might be that you need the evidence that you hope to adduce from them in order to prove your case. Now,
and a lot of the work that you do, well, I mean, in the Supreme Court, evidence is done on witness statements, I think, and a lot of times, but in the district court, it's viva voce. So you can't always plan your cross-examination with months in advance because you don't know what they're going to say. Is that something that adds to the fear of it, or the
well, it's not something to be afraid of, in my view, but you do need to know what the case is that's going to be put against you. And that's the role of pleadings, and it's the role of particulars. And
they're often often generic sometimes.
Well, they
generic,
can be,
yeah.
but which leads me to the point I was about to make, which is that too few people seek particulars of defences in common law cases. I mean, particulars are almost invariably sought of statements of claim, but I think that there is a role for seeking particulars of defences. I mean, that's particularly so in cases where the defendant bears a positive onus. So in a lot of the work I've found myself doing in recent years, which are cases essentially involving trespass.
So these some of the police tort cases you've been doing?
Right.
Yeah,
that's right. So all you have to prove is the fact of the battery or the assault or the fact
or the illegality of the arrest or the...
Well, no. What you're... And this is my point, that as a plaintiff in those cases, all you have to prove is the fact of the battery or the assault or...
The arrest took place.
The imprisonment. So the detention. And then the onus is on the defendant to establish a lawful justification for it. And there's a real role for particulars in that situation, but I don't think it's confined to cases where the defendant bears a positive onus. I think that
just one question on cross-examination still. Is there any room in your experience for to adopt a poor expression, to put on a show for a client? I mean, where your questions can't necessarily, you're sort of stuck in a corner where you can't elicit the concession or qualify the fact or contradict, and you sort of need to do something. Is there any role in a jury case or before a judge to sort of put a narrative or put on a show, to speak, in cross-examination?
Well, I would caution against it, because if you want to put on a show, by that I take you to mean that you move away from the focus that should be that of cross-examination, which is obtaining the evidence you need and the concessions you need. And if you start moving away from that, then you're probably giving dangerous latitude to the witness. So I'd caution against it. That's not to say that there isn't a place for theatrics in a courtroom, but I think the theatrics should only be they should be limited to a situation where you are still
because just
seeking
yesterday
to achieve
we
your
were
purpose.
I was coaching the readers course on the cross-examination workshop, and so I was discussing the folly of just putting on a show, so to speak, or not having a particular forensic purpose in your questions.
Well, it's extremely dangerous for junior barristers. Extremely dangerous.
But something they might think, having watched a few too many, legal dramas, as I think other people on the show have said that our judges have said that they think that people who do that might have been caught in that trap, that's good advocacy, but obviously not in your view, and I think in those judges' view who's come onto the show. Dominic,
I think what I would say about it is this, that barristers should never make the case about themselves.
Exactly. Yeah. Dominic, that your reference to the work that you do, or one of the main areas of work that you do in sort of liberty work, police torts and the like, brings me to a case I wanted to discuss with you. But before I do that, I'm going to give you, I hope you haven't been able to see my notes, I'm going to give you a testimonial, and then that I was given by somebody who I won't say how I even know about this, but and then we'll talk about a case, and then I'll see if you can link the two. The testimonial was that you are a knockabout bloke with a penchant for good grammar and fair play. Could you guess just off the bat who that might be?
No.
Good. So before we get to that, I mean, so the case I wanted to talk about was State of New South Wales and Robinson. I'll say that I am here as the only person sitting at this table who hasn't been to the High Court, and who hasn't been to the High Court and won, because obviously you were successful in that case.
We were narrowly, but a win is a win is a win.
Narrowly, and I was going to get to the narrowly and how the narrowly played out live, because it's interesting for all barristers and probably beyond, the process and the experience of running a High Court case. I wanted to, just for very basic factual and legal issues account of the case, it was a wrongful imprisonment case dealing with Section 99 of LEPRA, the Law Enforcement Police Responsibility Act.
Powers and
Responsibility Act, my apologies.
That's right.
And in that case, the arresting officer, there was an arrest without an intent to charge. Is that right?
That's correct.
And that was evidence that was given by the officer at first instance, that he said he didn't really at the relevant time have the relevant intent to, or the idea that a charge was or could be formulated in respect of this particular plaintiff. Is that right?
Yeah, that's right. And of course, by the time it got to the High Court, that was not a matter in issue. The appeal proceeded on the basis that at the time he effected the arrest, he had not formed an intention to charge.
Yes, and he needed to do so. The test was that he had to suspect on reasonable grounds that the person had committed an offence, and that was something that just couldn't be satisfied.
Well, no. I mean, Robinson was about more than that. It was a suspicion on reasonable grounds is necessary if an arrest is to be lawful, but it's not sufficient. That was really the point about Robinson. Yes. Because the purpose of an arrest is to take a person before a court and make them answerable to a criminal charge.
Yes.
There is no punitive purpose in arrest. And our principal argument was that if indeed that is the central purpose of arrest, and indeed it's a duty imposed by Section 99(3) to take the person before the court as soon as is reasonably practicable.
Yes.
Then unless that is your intention when you effect the arrest,
how can you be wanting to take them through to a magistrate or what have you if you didn't have that?
Yeah. And the state's argument focused, unsurprisingly, on amendments that were made previously to the Crimes Act, to the power of arrest that previously existed there and later was transposed into LEPRA, which permits police to hold people for the purpose of investigation.
Yes.
In certain circumstances. And the state's argument was that the introduction of those provisions had changed the hue of the power and had moved the focus away from a situation where the intention had already been formed. So ultimately, it became a question of whether it can be permissible to arrest someone to investigate.
Yes.
And we argued that none of the changes that were brought about allowing police to hold people for a period before taking them before a court for the purposes of investigation had detracted from that central proposition, which is that the purpose of an arrest is to take them before the court.
But these are fundamental things to civil liberties and the like.
Absolutely.
I was going to say,
it's very important public interest. I'm sure you had no
difficulty establishing that in your special leave application to High Court that the public interest aspect of this case was satisfied.
Well, I mean, the High Court, I think it's fair to say, granted special leave with alacrity, and I'm sure for that reason it is quite central to civil liberties question.
But in a landscape where we continuously see legislative reform eroding common law freedoms that have been the bulwark of our society for some time, a case like this was actually quite seminal in the sense that we won it 4-3 and the power of arrest was limited in the way it was. I mean, that must have been quite satisfying, at least at the time, to sort of take one for civil liberties.
Sure. Well, I mean, it's very satisfying to be involved in a case which marks out the boundaries of the law in an area that is so important and is in operation every day of every week, of every month, of every year.
It was a 4-3 success in the case. Did you when you were on your feet in the High Court there in front of the 7 judges, did you get a sense that they were divided and you had to work hard in your submissions or in any Socratic exchanges you had with the bench there?
Yes. Yeah. I mean, it was heavy weather for me at first. But it was an exhilarating experience. And I did have the feeling that we had found favour with our argument with a number of the judges, but frankly, I did not know how it was going to go.
So you really were, because we had Malcolm Turnbull on the show a month ago, and we talked about his one trip to the High Court, which was also successful in the Spycatcher case. And he said he had a moment where he said Tony Mason, Anthony Mason, said to him, well, they won on a public international law point that the legislation that the British government was seeking to enforce, which the Public Secrets Act, wasn't applicable in this jurisdiction. Yeah, well, which everybody, I guess I'm saying it for the benefit of people who may have not heard that episode or know about the Spycatcher case, but and that the Chief Justice sort of said to him, look, you know, if you're successful on this point, if we accept that point, you win. And he sort of knew at that moment, and then it was put to his opponent there, Simos, who, you know, and the three other silks sitting against Malcolm, who was on his own as a solicitor, that would be the case, and he had to agree. And he kind of knew at that moment, I think he was saying that he won the case before the judgment came down.
Or at least the issues became so narrow for him.
Became narrow, and that he was a very good chance. Whereas in your case, it sounds like you were awaiting the judgment with bated breath or more.
I thought that it would be a divided bench. I just didn't know how the numbers would fall. And I think if you were to speak to Jeremy Kirk, who was my opponent now of the Court of Appeal, he would probably say the same.
Yes. Yeah. And also, obviously such an important issue that, and quite nuanced actually, and the way you've described it. I mean, mine was a gross oversimplification really, but probably not an easy way through for all the judges, and they were divided on their views about this particular power and how the extent of it.
Yeah, I mean, ultimately the question was, as I said, whether the power to detain, to investigate, which had been relatively recently introduced to the law of arrest, at least in New South Wales, had diluted the previously accepted central proposition that arrest must be for the purpose of taking someone before a court to make them answerable to a criminal charge. And it was tested in this way in our argument. We said, suppose that there is nothing that can be done to further investigate whether the person arrested in fact committed the offence they were suspected of. At least there was nothing that could be done by holding them at the police station.
Yes.
And that there was a magistrate sitting next door to the police station twiddling her thumbs. In those circumstances, how could the arrest be lawful? When there's a duty within the provision to take the person before a court as soon as reasonably practicable after arrest. And what did they do? We asked rhetorically. They take the person in and say, well, we're bringing this person before the court. And the magistrate would say, thank you, that's good. What's the charge? Oh, we haven't charged you.
Yeah, exactly. But sometimes in cases with submissions, and we're kind of a little bit back to court craft, to bring it down to a really practical, real-life example like that brings home your case theory and your proposition so effectively, doesn't it?
It can do.
Like a good one, like that. I mean, and people think, the judges, anyone would have to think, well, actually, it just eliminates the thing. I'm just going to go back to the testimonial. So are you getting any hints on who, we've just talked about Robinson, who the testimonial might have been given by?
Well, if it's someone involved in the case.
Who would use that language involved in that case? Would it be Joe Fay, humble Joe Fay from Foot Law in Grafton?
It could be.
Yeah, well, it was. I know Joe reasonably well, and he himself is a knockabout bloke, and maybe that's why he used that language. But I thought it was, I'd be happy to be referred to that way.
He's also a very good solicitor, Joe.
Indeed.
Not to be underestimated. He disarms people with his knockabout way, but don't be fooled.
He does, and you with him he was your instructor in Canberra. He said that all you'd really let him do is make the sandwiches, but get by the sandwiches, and otherwise told him to keep out of the way. But he said he was a great experience for him too. So you also, when one does a case like that, one ends up obviously getting known as in that area, and sometimes that happens just by happenstance when you're a barrister and you fall into a type of work. This has happened to you in a sense with these sort of, if I can call them liberty cases. So you did another one recently, Dennis. But that one wasn't as successful. Was it in front of the New South Wales Court of Appeal?
That's right.
I
lost Dennis.
Were there similar issues there? Could you tell us a little bit about that case and if there's a line between that and Robinson or?
Yeah, there'd been a debate.
About considering alternatives to arrest, wasn't it? Rather than. And again in 99, whether that's something that you need to do when acting in or pursuant to
Talking about
99.
losses is never as fun as talking about wins, but
Well, we could just leave that. I guess
I'm happy to discuss it. I mean, Dennis is the culmination of a number of cases. There had been a debate going on about whether there was an objective element to be introduced to the question of whether the police officer was satisfied of the reasonable necessity for arrest. So there's undoubtedly an objective question in the first part of 99, which requires a suspicion on reasonable grounds of the commission of the offence by that person. But there was a line of authority which suggested that there was also an objective element to the second requirement, which is satisfaction on the part of the arresting officer. And effectively what the Court of Appeal has done in Dennis is to put that to bed. Now, the question of satisfaction, it doesn't mean that it is not a justiciable question, but it's justiciable really on administrative grounds.
That's right. There was very much a component of that in Dennis, wasn't there?
Yeah. So you're getting into the territory of legal unreasonableness, which the High Court has dealt with on numerous occasions recently, but perhaps Lee is the case.
Yes,
LI is the case most cited. And yeah, we got into that area, and I think, ultimately the result in Dennis came down to the conclusion that, having regard to the facts of the case, legal unreasonableness could not be established and ought not to have been found by the primary judge.
Thus likes legal unreasonableness, don't you? We've talked. Did we talk about that with ex-Justice James Allsop? Chief Justice Allsop.
James Allsop. What I found so interesting about what he was talking about unreasonableness was how he saw it develop from a complete no discussion of transgression into merits into a sort of a shift in conception and application of unreasonableness into the scope and power and purpose of legislation. So you look at it, you look at the decision through the prism of what was the scope and purpose of the section, rather than just saying, no, this is a complete transgression to merits, we're never going to look at it. And I think it's developed into a real interesting judicial discourse.
For the lay listeners, the distinction, as you've rightly pointed out, is between merits reviews of a decision made by someone in whom a power is reposed. In Dennis, of course, the repository of the power was the police officer. So between reviewing the merits of the decision that police officer actually made, which the court is not permitted to do, and examining, on the other hand, the question of whether what the police officer did do was in fact beyond the power reposed in him.
Yeah, or not. Or within it.
Or within it, that's right.
And legal unreasonableness seems to sit somewhere in the two of those, doesn't it?
Well, no, it doesn't actually. The High Court has been at pains to explain that legal unreasonableness is concerned with the second question. That the ultimate question is always whether the decision made was within power. And if made within power, it doesn't matter whether the court even considers that it was an unreasonable decision. It will not be disturbed. So legal unreasonableness requires something more than Yeah, we don't think.
But keeping in mind the power that's being exercised is my point. Isn't that what James Allsop is saying?
That you've still got to keep in mind that what the power that is being exercised when assessing the level of unreasonably, whether it's legally unreasonable.
Of course.
So that's simply my point. That's
Of
why it sort of
course.
sits between the two. But I mean, obviously there's one and the other. I get that.
Yeah.
We wanted to talk about you are president of the Bar Association, so it's not every day we get to speak to someone who holds a position of that nature in what we do.
Yeah.
We're really we're interested in a few things about the workings of the Bar Association and how. I mean, there's a few different hats. I mean, at one level, the Bar Association is representing and protecting the interests of barristers as professionals and as workers.
Yes.
But then there's this other role where the Bar Association speaks out on behalf of barristers because you and the other committee members and the like are democratically elected by us on bigger issues, on legal issues and what have you.
That's an important part of our...
Indeed. And this is something that I get the sense is important to you as a president, but too important to as you as the receptacle of that kind of us and the committees that obviously you consult with.
So what drove you to the service model? What drove you personally?
Well, I'd been at the bar for 2 years when I was approached by a much more senior barrister who was practicing in the common law field, and he brought to my attention the fact that there is a quota for barristers who've been at the bar for less than 5 years. So under the constitution of the Bar Association, there have to be at least 3 under 5s on the Bar Council.
Under 5 year post core.
That's right. Yeah. Under 5 years core.
Yeah.
Yeah. And he encouraged me to run, and I did, and I was elected. And I've been on the Bar Council now, I think been at the bar for 26 years, and I think I've been on the Bar Council for about 23 of those 26 years. And I've enjoyed it immensely. So just to explain to you that the structure of the Bar Association is that it's governed by a council, which is, in corporate terms, the council is the board of directors.
Yes.
The council is comprised of 21 barristers, and it's those 21 who are elected by the membership. And then the council of 21 elects an executive, which comprises a secretary, treasurer, a junior vice, senior vice president, and the president. Yeah. So it's the council who makes policy decisions, and it's the executive who execute them, as the name suggests. But none of it could be done without the work of the committees, and there are now 24 committees of the Bar Association, which are largely comprised of barristers. I say largely because on the professional conduct committees there are community members as well.
That's a good thing, isn't it?
Absolutely.
I mean,
without doubt.
It's, for obvious reasons, I just... So.
Without doubt. And so the committees perform the function of advising the council on many things. They prepare submissions for the approval of the council,
because they are expert barristers,
often
invariably practicing in that particular area of relevance to that issue.
Yeah. So take the criminal law committee. There's a lot of legislation in that particular field, and the Criminal Law Committee, well, going back a step, we are frequently asked to provide submissions concerning proposed amendments to the law. And so in the field of criminal law, we will seek the assistance of the Criminal Law Committee,
Can we take
and
an active
perhaps
example?
the Human Rights Committee as well.
Indeed, just so we can bring this back to sort of recent examples. So I read a letter in I think the winter edition of Bar News that you, at your president's letter, when you you wrote on 3 issues that the bar had been sort of working on or advocating. One of them was cannabis possession.
Yeah.
And that the bar advocates for legalisation of that.
Our position is one of decriminalisation of possession. Yeah.
And so how has that view sort of reached to come organically? Is there, how many committees, for example, would there be consultation with on that, and
Well, that has been a very long-term position of the Bar Association. I think, in fact, that it goes back perhaps even to the 1970s that the Bar Association has been advocating for that. But yes, certainly that policy would have been developed with advice from criminal law committees.
But in doing that, you were
etc.
relying on the special commission provided the most comprehensive examination on illicit drug use, and the inquiry recommended a whole bunch of matters for drug law reform, which you thought were very carefully considered, and
which the bar thought.
When I say you, the bar.
The ICE inquiry, indeed. I mean, that's an extremely carefully considered report. It was a comprehensively conducted inquiry. Sally Dowling SC, now the Director of Public Prosecutions, was Senior Counsel assisting, and it's a report which I would commend to everyone. I mean, the point about it is this, that the answer to a situation where someone is found in possession of a drug for personal use is not to drive them into the criminal justice system. It is to address whatever was going on in their life that led them to that. I mean, I would add that we, of course, recognise that many people use drugs recreationally. They always have. And there's a real question about whether the criminalisation of it makes any real difference to the level of use in the community generally. If it doesn't, and there's a lot of at least anecdotal evidence to suggest that it doesn't, then why, I ask, do you want to compound what is, in the case of at least some people, a medical problem by diverting them into the criminal justice system rather than into a system which will assist them and will address the problem that is sought, we think, to be addressed by the criminal law. The point is really that the criminal law is not achieving its purpose when it comes to the criminalisation of possession and use. That is not to say that the Bar Association takes a position which is a free-for-all. It certainly doesn't. And we maintain very strongly that the supply of drugs should remain a criminal offence. And if that position is to change in respect, for example, of cannabis, if the association's position is to change on that, then it would involve wide consultation and detailed advice from the relevant committees, and it would involve, no doubt, robust debate at council level. That's not our position. So,
Dom, another area that I saw that struck me particularly as some pretty powerful advocacy that the Bar Association has presented upon is the proposed changes to the liability and entitlements for psychological injury. And in particular, I noticed that in a report published about the responses to that proposed legislation, you actually gave evidence. And to a
I did to the first inquiry. Yeah.
Can we just give some background, a little bit more detail on it? The proposal is, as I understand it, in very broad terms, is that for work injury cases involving an allegation of negligence, that in order to qualify to bring a case of that nature, if it involves a psychiatric injury, that psychiatric injury has to be assessed at and this is a slight term of art, a whole person impairment of 30%. Is that in broad terms correct? That's the proposal for...
as well as connecting injuries to sort of compartmentalising injuries from a relevant event. So there was lots of issues that...
And the argument is that 30% is extremely high, and very few persons who may suffer a psychiatric injury in the workplace would traditionally, or in the experience of what we've had to date, would reach that level of threshold. And so therefore there'd be many less people who would be entitled to have a claim.
Yeah, well, the position is that by default it would mean that, Nick, in respect of common law claims. So if someone wishes to bring a claim for damages,
yes,
which are paid as a lump sum once and for all, that ends all entitlements, they would have to establish under the government's present proposal, they would have to establish a whole person impairment of at least 30%. Now, the reason I say that's the default position is because under the legislation you cannot bring a claim for damages unless and until you've brought a claim for any lump sum compensation entitlements under the Workers' Compensation Act.
Yes.
And it's at that point that the legislation has imposed this 30% whole person impairment threshold. So, yes, the effect of that is that it's introduced a de facto threshold for common law claims as well. But we accept and we have made comprehensive submissions, both orally in the evidence that's been given by me and indeed by David Hook SC and Hilbert Chu SC to the second inquiry in the upper house. We accept that a financially sustainable workers' compensation system is essential.
This has been the concern that's sits behind this movement or this push by the government. Is that right?
That's right.
It's a financial thing. How can we pay all these people? How can the state, the taxpayer, because it comes ultimately from there, the insurer, the state insurer, how can it afford to service all this claim?
Well, and eventually that it has to be paid through premiums by employers, and this is the issue. But we have provided a detailed submission, which I won't get down into the weeds of with you today, but which suggests that there are many ways that the cost to the system of claims for psychological injury can be reined in on a principled basis. But it is an unprincipled basis to impose a much higher threshold in respect of psychological injury just because it's a psychological injury. It suggests that psychological injuries should be treated in a separate class. Indeed, it does treat them as a separate class of injury, and they can be just as disabling as physical injuries, if not more so.
And the science on that's indisputable. Yeah.
Indisputable. And our objection to imposing that threshold is that the universal experience of people who practice in that field, and indeed the doctors who provide opinions and treatment to people who have suffered workplace psychological injuries, is that at 30% whole person impairment, you are probably catatonic and almost certainly hospitalised. And we do not regard it as a proportionate response to what is undoubtedly a future funding problem for the Workers' Compensation Fund.
To take those two examples, these are really rights of the individual. Again, we're into this territory, if I can use the term loosely, of civil libertarian values about individual rights against the state seeking to pull those back. Do you think that the bar is effectively, it could be, or as a group, or barristers as a group, could be described as civil libertarian in a way, in its value system traditionally, and the way that it advocates on these issues?
Well, I think that the common law itself is very protective of civil liberties. I'm not sure that I would class the workers' compensation case in the civil liberties basket.
Yes.
But if I can just complete the point I was making about the civil liberties basket, it is that the common law regards personal liberty as the most precious of common law rights. And if that right is to be fettered in some way, then it has to be done in the clearest of terms, and it has to be, if it is to be done in a principled way, it has to be proportionate to the issue it's seeking to address. Now, obviously, police officers must have the power of arrest. Obviously, they must. The question is, to what extent do you permit them to exercise that power? What are the metes and bounds of that power? And that's ultimately a matter for legislators. But that's where the Bar Association has an important role to play, because we can remind the government of the day of the legal position, not only now, but of its history. And we can warn against perhaps unforeseen consequences from legislative reform, and
highlighting
that's
the true implications of and reach of the potential reach of those changes.
Yes, and that's because we have the expertise to foresee it.
Yes, indeed, and that's exactly where the consultative and advocacy role comes in, and what. Yeah. And why, and whether could be described as a civil libertarian position is, I suppose, possibly not to the point. It's really about what we're trying to achieve in the traditions of the common law and the things that we just have to hold dear, because that's what we're doing.
This, sorry, I didn't mean to cut you off, but this motivation to have the institution as a force for speaking up against issues or protect fundamental common law rights in the sense that you've just described. Is that motivation, or is the power behind that, do you think, protected? Is the institutional integrity of that motivation protected? I raise that because we see in overseas, and in particular we discussed on the last podcast with Mr. Turnbull, was that he found it astounding that the attack on the rule of law in America hasn't been met by some sort of uniform response to the way the executive is dealing with lawyers and prohibiting them from entering into government buildings if they're doing things. Do you think there's some risk or some fragility to our power, or at least the power of the Bar Association to continue lobbying, or not lobbying, but being a force?
Do I think there's a risk to it being a force? I think the answer to that is no. I think that the Bar Association will always be a force when it comes to law reform, but more particularly in advocating for the rule of law. The general public enjoys freedoms every day in our liberal democracy. The protections of which, many do understand, but many don't understand. And lawyers are particularly well placed, of course, to understand the importance of the rule of law to our personal freedoms. So I regard it as absolutely core business of the Bar Association to speak up wherever the rule of law is being attacked and wherever judges are being attacked in an ill-informed way. It's a very serious thing to accuse a judge of acting other than in good faith. I think that it's perfectly legitimate for there to be public discourse about decisions made by the courts. Of course it is. And that's really an incident of the very important principle of open justice. But it is another thing entirely to be attacking judges personally, that is, by suggesting that they are not acting according to the oath that they have taken. And wherever we see that, I think that there's a role for the Bar Association to speak up about it, and I have done so. That traditionally, I might say, was something that fell to the Attorney-General to do. Not exclusively. Of course, the Bar Association had a role to play there as well, but traditionally Attorneys-General would step up to defend judges. And I think that tradition probably comes from the somewhat different position of the Attorney-General in the English tradition, and still the case that the attorney in the UK tradition is more akin to the Solicitor General in our system, and is less a politician, if I can put it that way. And I suppose that's just an evolution of the position, and I'm not being critical of anyone, but I think that given the evolution of that position, that it's even more incumbent on the bar to keep an eye on that sort of thing.
Interesting observation. Hadn't thought of that. There's so many different of these issues, but it's great to get a feeling from your firsthand of really how
the bar and the Bar Association feels about these things and why, and it's given us, and I think probably our audience, and hopefully beyond our audience, to the general public, great confidence to see why it is, and it's not out of some, it's far from some, for example, the protecting barristers to say, well, you know, we wouldn't want these thresholds to be lifted because there'd be less work for barristers. Because I think sometimes some people can be cynical about why the Bar Association might take a position that there may be some self-interest in it. But it's clear to me from what you said, and that it's entirely far from it. And we're just, we and you and the committee are in type. We are doing exactly what we are meant to be doing, but at a broader level, and that is protecting the rights and freedoms of individuals and the rule of law.
Yeah, I mean,
it's good to know.
It's not to say, Nick, that the Bar Association does not from time to time take what could be described as a political position.
Yes.
I mean, for example, the Bar's position on decriminalisation of possession and personal use of drugs is in some respects inherently political, but it comes from a place of expertise where the Bar has a very close first-hand experience of how that law is working on the ground, so to speak.
It's a little bit like sentencing, and judges get criticised for sentences they hand down.
Quite so.
You never hear about all the things and all the backgrounds and all the background and antecedents that these judges have to learn, all the psychiatric reports they review, everything, where they get a complete picture of the individual, intimately aware of the frailties, perhaps even the reason, not the justification necessarily, but the reason that brings the person into the criminal justice system.
As James also said, the critics don't have to do it.
Yeah. And it's a similar situation, I think.
You know, it is often said as a bit of a catch cry that judges are out of touch, and I'm not the first person to make this point, and I'm sure that Chief Justice Bathurst was not the first person to make this point. But the point he did make was that far from being out of touch, judges are in fact the ones who are seeing the ugly side of the criminal law all the time.
Yeah, exactly. Dominic, I know back to the Joe Fay's great testimonial that you have a penchant for proper grammar. What's your view on the and/or? There's a district court judge, a well-known district court judge who we don't need to name here, who quotes actually from a law lord who described it as the bastard conjunction. What's your view on it? Do you ever use it, or is it sort of out of bounds? Is it devoid of meaning, or does it have a use in legal writing and, per se? Because we aim for precision, don't we?
I avoid it myself.
I was thinking that might be the case.
I think it's usually unnecessary, but and I think the point can be made in other ways if you do mean or also.
Yeah, that's
to
right.
be conjunctive and not just
disjunctive.
disjunctive.
Yes, that's right.
Exactly.
That's right. That's the dichotomy.
Oh, yeah.
Thank you. Thank you, Dom. Thank you
pleasure.
for...
It's really been great to hear from you, and just to get a sense of something you're representing us, but
and thank you for the
like the way
work
you're doing
that
it.
you do for the Bar Association. Thank you for being...
It truly is an honour. It really is.
A sounding board to me.
I enjoy doing it.
You've been a sounding board to many juniors, and they feel comfortable to call you, and you've been a mentor to many, so we're all grateful.
Well, that's perhaps the best testimonial you could have.
Thanks, Dominic. Thanks for having us. Thanks for coming on.